Everybody, and thanks so much for joining us at Secular AZ today. For those who are joining today, please feel free to put your name in the chat in the webinar or on, we don't have it on Facebook yet. We're working on it. White Christian nationalism is the greatest threat to our democracy, and Secular AZ is your voice for the separation of religion and government. We are a nonprofit organization, and we act as your voice to elected officials all across the state and at every level. So be sure to check out all of our social media channels. Please like, subscribe, share. It helps with visibility. Next weekend, we are going to be participating in Lookout Phoenix's Summer of Solutions series. This is June 21st, 2024, which is next Sunday from 11 to 1. I encourage you all to register for that. And next Friday, our speaker will be Dr. Lauren Horn Griffin. Dr. Griffin is assistant professor in the Department of Philosophy and Religious Studies at Louisiana State University. Her research and teaching focus on religion, politics, media, and technology, so you will not want to miss that one. Also, it is when I went to New Orleans, we saw quite a few school board members from there, and you would not believe how many of them start off their school board meetings, their celebrations, their graduations with religious indoctrination. It was really startling. And I'm sure it's probably a common practice throughout many places in the South. So that should be interesting hearing from her. But for today, I'm really excited. Today, we are speaking with Professor Barbara Atwood. She is the Mary Ann Richey Professor of Law Emerita and co-director of the Family and Juvenile Law Certificate Program at the University of Arizona James E. Rogers College of Law. Professor Atwood's scholarship explores topics at the intersection of civil procedure and family law, with a particular focus on issues of voice and representation for marginalized groups. So your work is like more important now than ever before, pretty much. And with that, Professor Atwood, I'm just going to go ahead and hand it over to you, and I'll field the questions as they come in.
Okay, thank you, Jeannie. I really appreciate the chance to talk to everyone. I actually only learned about Secular Arizona a few months ago when one of your members approached me about doing this. I didn't know anything about the organization, so it sounds like a great group, and I think filled with a lot of kindred spirits. So what I was asked to talk about today is abortion law, and particularly Arizona law. And when I was first approached, there was more chaos in Arizona than there is right now, but abortion obviously is still a very volatile issue, and it's on the ballot. And so I thought what I wanted to do is walk you through some of the developments in abortion law in our state first, and then look at what has gone on nationally to some extent, and in particular, some recent U.S. Supreme Court decisions, and sort of end with talking about what's on the ballot and how that might affect the law here. And I really do prefer that this be a conversation. So as you are watching my little PowerPoint presentation and listening to my remarks, when you have questions or comments, please do let Jeannie know, and she'll let me know. So I'm going to try to share my screen now, and let's see here. And whoops, I'm going to go to the slideshow from the beginning.
Excellent.
Okay, so there is chaos. I'm going to move this up. Abortion chaos in Arizona and elsewhere, and there is continuing chaos in the United States ever since the Dobbs decision. Interestingly, some of you may have seen in the last data report that we have that the number of abortions performed in the U.S. actually has increased since the Dobbs decision, and there are some competing theories about why that's the case, but we do know that states that are friendly or receptive to abortion rights have become even more receptive and have made it, have enabled people from very restrictive states to travel to those states, to the receptive states, to get abortions, and mifepristone, fortunately, is still available, abortion medication, and that has become an even more dominant piece of abortion services in the US. So it's a very changing landscape, I'll put it that way, in the US. But just focusing for a few minutes on Arizona, and going back to the beginning, the famous territorial ban on abortion first became part of our law as in the territorial code when the Civil War was still going on in 1864. And this slide has the wording of that statute: a person who provides, supplies, or administers to a pregnant woman any medicine, drugs, etc., or any instrument to procure the miscarriage of such a woman, unless it was necessary to save her life, faced imprisonment for not less than 2 years, no more than 5. That statute was then codified when Arizona became a state, first in 1901 before Arizona was a state, and then again when Arizona was a state, and continued to be recodified in our laws using really that same sort of odd language, a sort of old-fashioned language. And there's a lot of history about where this came from. It was enacted in a code that included provisions like men were the dominant heads of household under community property law. Women didn't serve on juries. Women didn't vote. There were no women in the legislature. The territorial legislature was composed, of course, of all of men, and they were white men. There were very racist provisions in this old code. So it's just to give you a sense of that's the language, and that's where it came from. If you bounce forward along this winding road in Arizona abortion law to 1973, that old ban was still on the books, and it was enforced over those years. There's some very odd cases that are reported in the court opinion decisions where people would bring jars with fetuses into the courtroom to prove that a woman had illegally had an abortion rather than a miscarriage. In any event, when Roe v. Wade was decided, shortly after that decision came down in January of 1973, a few months later, the courts in Arizona, the Court of Appeals, struck down, invalidated this old abortion ban, which was, remember, no abortion from conception forward, except to save the life of the pregnant woman. After 1973, the Arizona legislature continually added to abortion regulations in the state. And there's been sort of constant litigation about whether they went too far under Roe v. Wade or not. But those abortion regulations included things like informed consent laws, and these are still now very much on the books. Very strict informed consent laws, laws that require a woman to make 2 visits in person to a doctor before obtaining an abortion, mandatory waiting periods, mandatory sonograms, restrictions on the use of telehealth, more recently, restrictions on the use of mifepristone, the abortion drug. It can only be prescribed in person in Arizona. And so you see sort of 50 years of abortion regulations being enacted in the wake of Roe v. Wade, and the legislature kind of pushing the envelope to restrict it as much as possible. Sometimes they went too far and the courts would strike it down, and they would come back with something else. In March of 2022, the Arizona legislature enacted what's known as the 15-week law, which prohibits the performance of an abortion by a physician if the woman is 15 weeks or more in her pregnancy. It's 15 weeks of gestation. unless there is a medical emergency. And this law was copied after the Mississippi law that was the subject of the abortion case in the Dobbs case that got rid of Roe v. Wade. So the Arizona legislature was looking at sort of out at the landscape, what was going on in the United States, and decided that there maybe was a good bet on this Mississippi law, that it was being challenged. It was going to go up to the US Supreme Court. People thought it might be upheld, even though it was clearly in violation of Roe v. Wade. Roe v. Wade, just to remind you, mapped out the trimester framework, and once it was construed repeatedly by the US Supreme Court, and as it stood before the Dobbs decision, it required states to permit abortion, elective abortion, up to the point of viability, up to the point of when a fetus would be able to survive outside the woman's body. With the states had to not impose undue burdens on a woman's access to abortion during that period of from conception to viability. After viability, a state could restrict abortion, but had to allow it to prevent death of the woman and to preserve her health. So it was what you see in the Mississippi law and in Arizona's 15-week law is something that's plainly not in compliance with Roe v. Wade. Nobody contends that 15 weeks, at 15 weeks, a fetus is viable. And so the Mississippi legislature was acting very boldly, and Arizona followed suit in enacting this 15-week law. And all eyes were on the court, of course, to see, is it going to be upheld? Are they going to throw out Roe v. Wade altogether? Initially, people didn't think they were going to throw out Roe v. Wade, that they would just significantly change its its impact and its interpretation. The wording of the 15-week law in Arizona is this, that a physician may not intentionally or knowingly perform or induce or attempt to perform or induce an abortion if the probable gestational age of the unborn human being, remember that term, because that's now relevant to another fight that's going on, of the unborn human being has been determined to be greater than 15 weeks, absent a medical emergency. And the penalty for violating that is if a doctor performs an abortion without determining the gestational age or does it without regard to the gestational age, is a class 6 felony, which can carry up to a little more than 5 years of imprisonment. And of course, loss of medical license if you violate this law. And interestingly, at least interesting to me, Arizona didn't copy the Mississippi law exactly. It was very similar to this, but Arizona didn't include an exception that Mississippi did include, which was if there is a severe fetal anomaly determined after 15 weeks, abortion would be permitted. Arizona did not include that exception. And complicating the interpretation of this law was a legislative directive saying, this is what we mean. The legislature included language in the law itself that says this law doesn't repeal by implication or otherwise Section 133603. And that is a reference to the territorial ban on abortion, recodified, or any other applicable state law. So they enacted the 15-week law, and then they said, confusingly, this doesn't repeal that old territorial ban, which wasn't in effect at all. It had been struck down by Roe v. Wade, but they were signaling that there was a legislative desire to keep that territorial ban in waiting, essentially. This was not what you would call a trigger ban, which about 12 or 14 states did enact saying if Roe v. Wade is overturned, we want the old law to come into effect. This is not exactly that, but as it turns out, the Arizona Supreme Court basically treated it the same way. So we get this happening in Arizona and in Mississippi. Then you get the Dobbs decision in June of 2022. And the language by Justice Alito for the majority saying Roe was wrong when it was decided. It's wrong now. We're overturning it. The Constitution doesn't confer a right to abortion. The authority to regulate abortion has to be returned to the people and their elected representatives. And we've seen the aftermath of that unbelievably significant decision. The decision was split. The court was split, of course, 6-3, but we are in fact dealing with that very momentous overturning of Roe v. Wade. Shortly after that decision came down, then Attorney General Brnovich filed a motion to lift the injunction against the old ban. So he went down to Tucson where the litigation had occurred and filed in Superior Court. It was a litigation against Planned Parenthood and said, Roe's gone, you got to lift the old ban. That old ban is now in effect. In fact, he tweeted that, he tweeted shortly after the Dobbs decision, he tweeted that the old ban was now in effect. And people are saying, he's tweeted that? Can he just make that happen? And of course, he couldn't just make it happen by a tweet. He had to go to court, but he did go to court and he prevailed at the Superior Court level. That judge's decision was that the old ban is now in effect because the only reason it was struck down was Roe v. Wade. Roe v. Wade isn't around anymore. The old ban now governs, and that spun everybody into great turmoil. That decision was overturned by the Court of Appeals in Arizona in a pretty valiant effort to sort of keep all abortion regulations and in place. But they said that old ban, we're not going to apply it to anybody except somebody who's not a doctor who is performing an abortion in violation of the law. That the Court of Appeals decision, I thought was a great effort to sort of salvage what remained of the protection for reproductive rights in Arizona. But it was not to last. In the meantime, of course, we had a change of administration, and that complicated things. We now have Governor Katie Hobbs and Attorney General Chris Mays. And while this litigation was going on, this case was working its way up to the Arizona Supreme Court, Katie Hobbs issued an executive order saying from now on, the Attorney General is the only person in this state who can prosecute abortion offenses. We don't want some county attorney in one state saying you're in violation of the law and county attorney in another state, in another county saying you're not in violation of the law. She said, this is the only way we can have some kind of centralized common understanding of abortion is to have it rest in the Attorney General's authority. And Attorney General Chris Mays made it clear these pronouncements basically came in June of 23 that she wasn't going to prosecute any abortion offenses and that the state would not assist other states if they chose to prosecute someone in this state for providing abortion services to someone who had come in from a very restrictive state. So she not only, Attorney General Mays was saying, we're not going to prosecute him here, and we're not going to help other states. We're not going to extradite people, etc. So that was a pretty bold statement, as a result of a very clear change of administration. Then you get to April of this year, the Arizona Supreme Court decides in a 4-2 decision that the old ban actually is effective, that the legislature never took it off the books, that we don't have Roe v. Wade anymore, we have no residual right to abortion, and that essentially the legislature intended for this to be the law once Roe v. Wade was overturned. And so we had this like skirmishing then, because the Arizona Supreme Court said that its own ruling was not going to be effective for some period of time. There were other stays that were obtained by the litigants, and it ended up that Supreme Court ruling was not going to be effective until basically the end of September of 2024. Meanwhile, as all of you witnessed, I assume, the Arizona legislature had a bill before it to repeal the old ban. That was going to be the only way to get it once and for all, off the books. And it took a while for the House and the Senate to reach a majority, because we had all Democrats supporting that bill in both houses to get rid of the old ban, to repeal it, and ultimately a handful of Republicans, very few, but enough Republicans to create a majority to vote to repeal it in the first day of May of 2024. That repeal, pursuant to general legislative provisions, wouldn't go into effect until 90 days after the adjournment. We now can breathe a sigh of relief, because the legislature adjourned in the middle of June, and that means that it will be the middle of September when that repeal becomes effective. The ban will be off the books. So the Supreme Court decision back in April is basically nullified. It will never go into effect. So that's the good news. The bad news is that the 15-week law in Arizona, which is now the law, is pretty draconian. It is not a generous law. It's true that most abortions, over 90%, I think it may be 95% of abortions, are performed before 15 weeks of gestation. But for those pregnant people who want an abortion after 15 weeks, the Arizona law is very, very restrictive in terms of of its availability. And I'll say a few things about that in just a second. Couple of side notes: two of the justices that were in the majority holding that the old ban should come into effect are now up for retention election in Arizona. Justice Clint Bollock, who used to work for the Goldwater Institute, and Justice Catherine King. There is an effort, I'm sure you've read about it, to vote them off the court in response to their participation in this opinion and their vote on with the majority. They are the only two of the majority that are up for retention right now. And I disagreed with the majority. I don't know Justice King. I've met Justice Bollock on a number of occasions. I am not in favor of their being voted off the court. I am not convinced that that's the right way for us to go. I think it threatens other values that are important, but that is definitely an effort that's being made right now. There's also, as you probably have heard, a ballot proposition directly in response to this effort to boot Bollock and King off the court, a ballot proposition to get rid of these retention votes, to basically ensure that justices and appellate judges, and actually Superior Court judges in the larger counties, would be able to serve during good behavior, unless they were convicted of a felony or had some other kind of egregious behavior. In other words, to get rid of this citizen retention election proposition. And that ballot proposition, which is on the ballot as a result, will be on the ballot as a result of a legislative referral, not a citizen initiative, came from the legislature. It's also retroactive, worded in a way that would protect Justice Bollock and Justice King in case they do get a negative vote, a majority of voters rather, vote them as not qualified to continue on the bench. So that's just, a side thing that we've got a lot of things going on in Arizona, but that's one of the issues, along with the other citizen initiative on abortion rights that has been the subject of a lot of controversy also recently. How am I doing on time, Jeannie? Because I don't know if I ever, do I have
You're fine. It's 12:27 now.
Okay.
There aren't any questions coming up, so just you go right ahead.
Okay, perfect. So I wanted to just switch for a few minutes to the national scene and talk about a couple of cases that were in the Supreme Court this term. The Supreme Court, I think when it decided Dobbs, it thought, okay, we're washing our hands of abortion. We're done with this like messy topic. And of course, here we are in 2024, and there will be more abortion cases. It's not as simple. It can't really remove itself from some of these ongoing controversies. This case was one that came up. It's the challenge to mifepristone, one of the two drugs, mifepristone and misoprostol, given together as an abortion medication. The group called Alliance for Hippocratic Medicine decided to sue the federal government, the FDA, in Texas. And their argument was that the FDA's original approval of this drug for abortion, it had been already approved for other uses, but its approval for abortion and the later loosening of restrictions were arbitrary and capricious, that they were beyond the FDA's authority. They wanted to get it off the market, basically. And the Alliance was a group of doctors who represented themselves as Christian and very opposed to abortion in all circumstances. And they were able to get the case filed in this federal district judge's court, Judge Kaczmarek in Texas, who ruled in a way that they anticipated he would. Before he was appointed to the bench by President Trump, he had worked for a Christian law firm and had been involved in things that were much like the Alliance Defending Freedom group in Arizona. Actually, that group is national and international now, and I'll say a few things about that in just a few minutes. But they got a very positive ruling from Judge Kaczmarek. He wanted to ban basically mifepristone altogether from the market. That ruling was stayed by the U.S. Supreme Court. It was then argued and modified at the Court of Appeals level, at the Fifth Circuit level, which said where it's too late to challenge the original approval back in 2000 rather, of this drug, but we think that the FDA went too far in 2016 and 2023, and the regulations that were at issue at the Fifth Circuit level and then that were appealed were brought to the U.S. Supreme Court were the regulations that said you can administer mifepristone at 10 weeks of gestation. It had been an earlier time frame before. It can be prescribed by a nurse practitioner. It doesn't have to be a medical doctor. It can be prescribed after only one session, one visit, but that doesn't have to be in person. It can be through telemedicine, and we can mail the drug to the patient. So that's what they were aiming at. And the US Supreme Court ruled that not on the merits. It just said this association, this group of doctors didn't have standing to bring this lawsuit. So the court essentially avoided having to address the legality of what the FDA had permitted with respect to this drug. The opinion dismissing the case for lack of standing basically said, you doctors, I mean, the doctors there were arguing that they were going to be forced to perform abortions against their conscience because this drug was available and the drug would lead to emergency needs, and the doctors would be forced to perform abortions, and that would offend them. And basically, the Supreme Court, in an opinion by Justice Kavanaugh, said that your desire, a plaintiff's desire to make a drug less available for others, just that's not how our court system works. That doesn't establish standing to sue. Standing refers to this idea that you have to have a stake in the controversy. You have to either have an injury or you're going to face a real injury. And this was a group of people that were ideologically opposed to abortion, but they couldn't make that showing. And so the court dismissed. That allowed a lot of people to breathe a sigh of relief. It leaves a question of who might be able to sue, because the court did not approve of what the FDA had done. It just said this lawsuit is out the window. And Kavanaugh, in his opinion, said this. He said, citizens and doctors who object to what the law allows others to do may always take their concerns to the executive and legislative branches and seek greater regulatory or legislative restrictions on certain activities. And that's basically a message that if you don't like what the FDA is doing, you can, elect an administration that will be more restrictive and will rein in what the FDA is doing. So it's kind of a political, you can change these things if you can't get into the court system, you have these other mechanisms. And mifepristone is absolutely if it were taken off the market, if it were restricted in the way that these plaintiffs wanted, it would hugely affect the availability of abortion.
We do have a couple of questions, Barbara. So the first one is coming from Mark, and his question is, why is there what appears to be a strong alliance between corporate capitalists and white Christian nationalists to restrict abortion, as well as defeat what appears to be all civil rights legislation, possibly dating back to the abolishment of slavery in the former Confederate States of America? That was a big question. So the alliance, really, the question is, why is there such an alliance between corporate capitalists and white Christian nationalists? I don't know if,
I maybe somebody else in your group has a good response to that. I mean, I don't have a good response in terms of what the link is. You do see those ideological themes appearing in these groups. I mean, in these same groups, but how how capitalism fits in with that is something that maybe somebody else has a comment on it. It's relevant to that question. I'll go to the next slide. These three cases that I've talked about, the Dobbs case, the Arizona Supreme Court decision, and this challenge to the FDA's approval of mifepristone, what do they have in common? Well, maybe they have a lot of things in common, but all three cases, the parties seeking to restrict abortion access were represented by the Alliance Defending Freedom. And that group is not only about restricting abortion rights, they are about also restricting LGBTQ rights. And they are for sure wanting to rein in recognition of same-sex marriage. They are about getting freedom, greater freedom of religion recognized in the public schools and in the, in other words, sort of going back on some of the decisions of the US Supreme Court. And so that the Alliance Defending Freedom has many allies in high places in the government. And I, the Speaker of the House, Mike Johnson, apparently is some affiliation with this group. This group it's headquartered in Scottsdale. It began in the early 1990s. It changed its name to the Alliance Defending Freedom somewhere around 2012. It is now a national group. There's a New York City and Washington, D.C. offices, and it is international with its international headquarters in Vienna, Austria. It is an amazingly powerful group. In the Mifepristone case, the woman lawyer who argued the case is Erin Hawley, who is Josh Hawley's wife, and both of them are she's a senior counsel with the Alliance Defending Freedom. So the reason I thought this might be relevant to the question is that that group it represents itself as a Christian law firm, work on religious freedom issues, but it takes, it's a very sort of anti-liberal group in its goals. Jeannie,
And
you were
yeah, they're also responsible for a law, a really overarching anti-LGBTQ law in Uganda, where it essentially, I mean, it makes being gay illegal and in some cases punishable by death. Like these people are serious Christian nationalists right here in our own backyard. And I mean, and I would add too, like there's a few other of those types of groups, right, Barbara? Like in addition to Alliance Defending Freedom, there's another one, I think that's called First Liberty Legal. And what we've seen here in Arizona is they're taking on a lot of the cases of school board members who are trying to bring religion into the schools. So they will do, they've got huge budgets, these organizations, and that's who our legal team is constantly fighting again. It really is a David versus Goliath, not to use biblical terms,
right.
but that's really what it is.
It is amazingly powerful. And you're right, they have litigated all over the world and worked in other ways to support the criminalization of homosexuality, fighting against any recognition of same-sex marriage. I didn't realize how widespread their tentacles were. It's amazingly powerful, and there's a lot of money involved. I mean, hundreds of millions of dollars in terms of donations. And the people that are associated with them, I mean, Justice Amy Coney Barrett has had some affiliation, Jeff Sessions, the Hollies, I mentioned Mike Johnson. It's people in power. And for the group that's watching this, you probably saw there was some reporting from New York Times reporters recently, and they turned it into a book about the fall of Roe and the way in which the fall of Roe v. Wade was a very strategic, organized movement with, strategically choosing the state of Mississippi and coming up with the 15 weeks as a way of getting at, and of course, they read the tea leaves, and when Justice Barrett was appointed after Justice Ginsburg died, they thought this was the time to act. So the history that these two New York Times reporters have uncovered is very chilling, I must say.
And I would like to read the Whit's actually the president of the Secular AZ board, and he puts it pretty succinctly here. He says division and control is highly probable. Keep us fighting with social issues while they build power and wealth. And that may be, you know, a kind of dark way of looking at things, but I mean, I'm sorry, capitalism is producing some pretty dark results right now. So like, and it kind of always has. There is one more question here. I'm so sorry. Let me,
Yeah.
because it was another great question. Rivon, who actually is another one of our members who started a satellite group, a liaison group up in the Sholo area. So if there's anybody that wants to find your people, she is your go-to. She asks, are there planned or pending cases to stop anti-abortionists due to violation of the Second Amendment freedom from religious beliefs in souls magically getting infused at conception?
I'm having a little trouble following that question. The Second Amendment is of course,
right to bear arms. Yeah. So I'm not sure.
So I'm not sure. Well, there are a lot of abortion litigation cases around the country. We have definitely not seen the end of it. There is one more case I wanted to just mention. And I'll just do that until maybe if you can figure out what that question is asking. But
this was First Amendment. She meant to say First Amendment, not Second Amendment. So are there let me go back to the question again. Planned or pending cases to stop anti-abortionists due to violation of First Amendment freedom from religious belief in souls magically getting infused? That makes so much more sense.
But so if she means there are cases that have been filed since Dobbs, arguing on religious freedom grounds that the state banning abortion violates certain fundamental tenets of certain religions. Judaism was the primary one that was advanced first in a case in Florida, and then one in I think it was in Ohio. If that's what she's asking, those cases, there's not been any clear resolution, certainly not from the U.S. Supreme Court, but there are, I think, pretty serious arguments where the idea is that you're forcing on me you're not permitting me to do something that I believe is central to my own spiritual beliefs, which is the ability to terminate pregnancy under whatever circumstances the person is arguing, but that it should be protected by religious freedom. There are people watching the U.S. Supreme Court because the Supreme Court has been expanding recognition of religious freedom in a series of cases in the last decade. And people are saying, well, this might play into that, but the court, we don't know what the court's going to do with this. I did just want to mention this last case, the other abortion case was on the docket in the U.S. Supreme Court this term, Idaho versus United States, and the Alliance Defending Freedom actually had a role in this case as well, because this is where the Biden administration, and I do give credit to the Biden administration for trying to do everything it can post Dobbs, every step it could take to protect what remains of sort of reproductive rights in the United States. And so here they were suing Idaho having a very restrictive law on abortion, criminalizing it except when necessary to prevent the pregnant person's deaths, very much like the old territorial law in Arizona. And the U.S. sued under a federal law, the Emergency Medical Treatment and Labor Act, saying, and that law basically requires people in emergency rooms in hospitals to stabilize patients medically, to make sure that they're okay when they come in with medical emergencies. It was a law that was designed to prevent hospitals from throwing people out because they can't pay for it or don't have insurance. So it was, a law that came into being during the Reagan administration. Didn't have anything to do with abortion, but the US was saying, look, when a woman comes in, a pregnant person comes in, needs an abortion for a medical emergency, you have to perform that, even if it's not something that's necessary to prevent her death. And so that's the case that was before the Supreme Court, and the Alliance Defending Freedom consulted with Idaho to help them build their argument that their law should prevail and not be subordinate to this federal law. And it wound its way up to the US Supreme Court. The federal district court had enjoined the law, had enjoined Idaho. Said, Idaho, you have to perform abortions if they're needed in an emergency under this federal law. The US Supreme Court reached down and halted that order. In other words, left Idaho law in place while this case was pending. And at the end of June, the Supreme Court said, oh, actually, we made a mistake even granting review. They dismissed it as improvidently granted, a term that's used when there's maybe some issue about the record, maybe some issue about somebody had waived something that it wasn't real clear, but they didn't get to the merits. They just dismissed it. But they did reinstate the injunction, meaning Idaho right now has to comply with EMTALA, and that's left it in just limbo. And Justice Ketanji Brown Jackson, who has, I must say, emerged as an absolutely brilliant and very bold new justice on the Supreme Court. It's a lot of text on this slide, but she dissented in that case. She said, look, we created a mess here. We suspended the injunction below. That meant that for the last few months, Idaho doctors have been airlifting patients that come into the hospitals who need abortions to preserve their health, and airlifting them to abortion-friendly states because of Idaho law that says you can't perform an abortion unless it's necessary to prevent the death of the pregnant person. She said, this is not a victory for pregnant patients. It's delay. While this court dawdles, the country waits. Pregnant people experiencing emergency medical conditions remain in precarious position. She said, this court has a chance to bring clarity and certainty to this situation. And we haven't done that for as long as we refuse to declare what the law requires. Pregnant patients in Idaho, Texas, elsewhere will be paying the price. We owe them and the nation an answer to the straightforward preemption question. I respectfully dissent. And she's so right. She's so right. It just leaves it in limbo. And this issue is very much alive in the states like Idaho that have an absolute ban on abortion, except to save the life of the pregnant person. So it's what the court did was create a lot of confusion and not answer any questions. Right after this decision came down, Chris Mays issued an attorney general opinion. It was the very same day that the Idaho case was dismissed. And she wanted to clarify what it means in Arizona, what this medical emergency exception is for abortions performed after 15 weeks gestation. Remember, that's what our 15-week law says. And a medical emergency is defined as requiring an abortion to avert death, or when delay will create serious risk of substantial and irreversible impairment of a major bodily function. And Chris Mays, in this quite well-reasoned opinion, I think, basically said, we're not going to prosecute any doctor who exercises good faith clinical judgment in determining that a medical emergency exists, and medical emergency does not require that the risk of death or impairment of a major bodily function be imminent. AG opinions are not binding on courts, but they are persuasive. And so, again, you see, I think Governor Hobbs and Attorney General Mays doing everything they can to keep reproductive justice to the extent they can alive in this state. Let me end by just focusing your attention on the proposed amendment. This is the Citizens Initiative. It's not a legislative referral that will be on the ballot, a proposed amendment to the Constitution. And the amendment basically declares that every individual has a fundamental right to abortion. It is essentially reinstating the standard of Roe v. Wade. It says no law restricting the right to abortion before fetal viability is enforceable unless it's justified by compelling state interest that is achieved by the least restrictive means. So it's a very high bar. You can't restrict the right to abortion before fetal viability unless you have a very compelling state reason, state interest, and you do it in the way that's the least restrictive. And after fetal viability, it protects the right to abortion if the medical doctor, the treating healthcare professional determines in good faith that it's necessary to protect the life or the physical or mental health of the pregnant individual. So that's a very carefully worded constitutional amendment. Right now, there's a fight that you maybe have heard about. The Legislative Council in Arizona that's responsible for putting together ballot information when these ballot materials go out to the citizenry. They have referred to the unborn human being, that this abortion, their description, their summary of this proposed amendment uses the term unborn human being when it describes the post-viability, abortion of the unborn human being would be allowed under these circumstances, and et cetera. And so the proponents of this amendment have said, wait a minute, you can't use that term, that unborn human being. That's partisan, and it will turn people against this amendment. And the response to that is from the people who have used that language said, look, that's the language that is used in the statutes as we have them right now in Arizona. And that's exactly right. If you remember back at the slide where I showed the language of the 15-week law, it does use the terminology of unborn human being when it spells out what the medical professional's rights are in terms of performing abortion after 15 weeks. So that's right now in Maricopa County Superior Court. We're going to hear what a judge has to say about whether that language stays. We know that polling shows about 60% or more of Arizonans want to protect abortion access under most or all circumstances. So we know there's a general support for this, but the ballot language and how it's described is going to be, obviously significant. But if the amendment passes, would the 15-week law be subject to challenge? Yes, it would, because remember the amendment says abortion access, elective abortion, up to the point of viability would be protected unless there's a compelling state interest related to the protection of the pregnant person's health. There's I think, no real argument to support the 15-week law under that standard. Arizona, as I mentioned earlier, has a very strict informed consent set of laws, actually, and requiring sonograms and 2 in-person doctor visits and some other sort of measures. Would that be subject to challenge? I suppose there will be people who argue that that's necessary to protect the pregnant person's health, but the wording of the ballot measure is designed to, I think, defeat some of these arguments because the ballot measure itself, when it defines compelling state interest as a law or regulation enacted for the limited purpose of improving or maintaining the health of an individual seeking abortion, and it does not, it cannot infringe on that individual's autonomous decision making. So they're trying to get around the argument that we need to make sure people who seek abortions know exactly what they're doing and that they are protected from regret later, which is a part of the law that developed under Roe v. Wade. And then there's the laws outlawing the use of telemedicine for abortion medication in Arizona and prohibiting the mailing of abortion pills. I think they would also be vulnerable under the constitutional amendment. So what we see right now, I think, is this issue is really, really important in the state, and whether voter turnout, that's going to be a factor. What happens with the top of the ballot, what happens with the presidential race is going to affect voter turnout for sure. But this issue is important in Arizona. What I think the arguments against it are going to be to portray the 15-week law as a moderate and reasonable middle ground. And actually the 15-week law it's very draconian in the ways that I've described. So anyway, that's about it for me.
Okay. There were a couple of questions. I had to switch to my phone. I'm at my daughter's helping her right now, and because my battery was going to die on my computer. There were a couple of questions in there, and so I apologize, folks, because when you switch to another device, it doesn't save the chat. There was one question in the Q&A where somebody was asking whether it passed. It did. Or not that it passed, but they got more than twice the signatures.
Over 800,000 signatures. So that won't, it'll be good on that front. This other side battle now about the wording of the informational pamphlet is, that can be quite important. And that's not resolved yet.
Okay. And I'm not really seeing any other questions in the chat. And I just want to say thank you so much for providing such comprehensive insight to this issue. I was there last week when the signatures were submitted, and it was really kind of an electrifying experience. But at the same time, I never in my lifetime thought that Roe would be overturned ever. Right. And so sometimes it's kind of hard to find hope. So when I, end these discussions, I like to ask people, what gives you hope, Barbara?
What do I hope?
What gives you hope? You're in a field right now where it's hard to find hope. So how do you find hope?
Well, I think the constitutional amendments here and in about 7 or 8 other states, that gives me hope. The fact that the electorate that people are actually making their wishes known. And in these constitutional citizen initiatives, that's sort of a form of direct democracy that I think is very promising. I see a tiny ear there. That's a lovely grandchild.
He gives me hope. He's the reason why I have to keep going,
That's a good point.
So thanks so much, everybody, for joining us today. I really appreciate it. And I appreciate you so much, Professor Atwood. Very, very, very interesting, very important conversation. And thank you so much for the work that you do.
I enjoyed it. Thanks.
I hope everybody has a great weekend.
Yeah, and vote, everybody vote, vote your
Yeah,
heart.
vote your heart out. Yes.
Okay,
Bye,
bye.
everyone. See you later. Oh.